Something extraordinary happened in federal court yesterday afternoon, something that, in my judgment, fundamentally altered the direction of this entire case. And I want to be absolutely clear from the outset. What you're about to hear is not conjecture, speculation, or creative interpretation. This is about a federal judge doing something judges almost never do in open court. She publicly confronted what she determined to be false testimony, backed that determination with documentary evidence, and in a single moment, dismantled the core of the defense's strategy. That moment occurred at precisely 2:47 p.m. By then, the defendant had been on the witness stand for nearly an hour and a half. His attorney had already completed direct examination. The jury had heard his carefully constructed narrative. He presented himself as a detached executive, someone who relied on advisors, delegated details, and remained unaware of financial irregularities until they were allegedly brought to his attention months later. He claimed ignorance. He claimed trust. He claimed betrayal. According to his testimony, he first learned of any valuation discrepancies in November of 2023 when his legal team showed him investigative findings. Until that moment, he insisted, he had no reason to believe anything improper had occurred. That claim wasn't just part of his defense, it was the defense. If the jury believed he didn't know, everything else unraveled. Intent collapses, mens rea evaporates. And once intent is gone, reasonable doubt doesn't just survive, it dominates the room. It's a classic strategy, simple, clean, dangerous. Ignorance, if credible, is a shield. Then the prosecutor stood up. At first, nothing felt off, no fireworks, no dramatic pivot. She began exactly how seasoned prosecutors always do, slow, procedural, almost boring. Timeline clarification, document authentication, names, dates, meeting locations, who was present, who signed what, when emails were sent, when drafts were revised, methodical, controlled, precise, the kind of questioning jurors half tune out, but courtroom veterans could feel it building because this wasn't about the answers, it was about the rhythm. She wasn't challenging his claim yet, she was boxing him in, narrowing his escape routes without him realizing they were disappearing. She asked about internal meetings in early 2022. He acknowledged them. She asked about quarterly reports he reviewed. He confirmed. She asked about emails he was copied on but claimed not to remember reading. He shrugged them off as routine. All harmless, all reasonable. Then she circled back, not to November 2023, but to 6 months earlier. She introduced a document, a valuation summary. His name was on the distribution list, not buried. Second line, do you recognize this document? Yes. Do you recall reviewing it? No. No pushback yet. Just a nod, a note taken, move on. Then another document, similar figures, similar discrepancies. Again, he was copied. Again, he didn't remember. By now, the pattern was visible, but only if you were paying attention. The prosecutor wasn't asking whether he knew yet. She was establishing access. Knowledge can be denied. Access is harder. She shifted tone slightly. Still calm, still polite, but tighter. She asked about a meeting in July 2023, one he admitted attending, a meeting where valuation methodology was discussed. Not in detail, he said, high level, routine. The prosecutor didn't argue. She pulled up the meeting agenda. Valuation adjustments were item 3. Then she asked a question that landed quietly, but hit hard. Are you saying that during a meeting about valuation methodology, you didn't notice any discussion of valuation discrepancies? He paused. Not long, just long enough. I don't recall specifics, he said. That answer sounded safe. It wasn't, because now the prosecutor had something far more powerful than contradiction. She had inconsistency. She moved faster now. Emails, calendar invites, draft memos, all dated before November 2023, all referencing concerns, adjustments, risks, none explicitly saying fraud, none dramatic, but together they told a story, not of innocence, of awareness. She didn't accuse him of lying, not once. Instead, she reframed his claim. You testified that November 2023 was the first time you learned of any valuation issues. Based on these documents, is it fair to say that November was the first time you were formally advised by counsel, but not the first time you were exposed to the issue? That distinction matters. Jurors understand that difference instinctively. You don't need to know something is illegal to know something is wrong. You don't need a lawyer to tell you there's smoke. He hesitated. That hesitation was the crack. From there, the cross-examination shifted from timeline to mindset. She asked about his role, his authority, his experience, years in the industry, prior deals, past valuations he had challenged personally when numbers didn't make sense. Each answer strengthened the same implication. This was not a naive executive. This was someone who knew how valuations worked, and when they didn't, then came the quiet blow. She asked whether he had ever followed up on those early documents, whether he had asked questions, requested clarification, flagged concerns. No, he said. So despite receiving multiple documents referencing valuation adjustments, attending meetings where valuation was discussed, and being copied on emails expressing concern, you didn't ask a single question until November 2023? Silence. Not from him, from the room. That's when intent re-enters the case. Because prosecutors don't need to prove he knew every detail. They need to show willful blindness, conscious avoidance, the decision not to know. The law treats that as knowledge. By the time she sat down, the foundation of his defense hadn't exploded. It had eroded, and erosion is more dangerous because jurors don't feel manipulated when it happens. They feel like they figured it out themselves. His argument that he didn't know still existed, but it no longer felt clean. It felt selective, convenient, carefully timed. November 2023 stopped looking like a revelation. It started looking like a line he drew after the fact. That's the moment every defense fears, not the accusation, the reframe. Because once the jury believes you could have known and chose not to, that's intent wearing a different suit. And intent, once it's back in play, doesn't need certainty. It only needs doubt to shrink. By the end of the day, nothing dramatic had happened. No raised voices, no objections, no gasps. Just a story that no longer lined up the way it did before lunch. That's how cases turn, not with explosions, but with alignment. And once the narrative shifts, it rarely shifts back. The room changed the moment the document hit the screen. Not loudly, not dramatically, just enough for everyone who mattered to feel it. Jurors leaned forward. One stopped taking notes, another squinted, reading the header again, slower this time. Defense counsel stiffened, the way you do when something doesn't belong where it's standing. The prosecutor didn't rush it. She never does. She let the silence work. The email was dated March 12, 2023, 8 months earlier. The sender line showed the defendant's name, not an assistant, not a junior analyst. Him, direct, unambiguous. The subject line was short and lethal. Valuation concerns, but need clarification. The prosecutor approached the witness stand, document in hand, voice calm enough to feel polite. Sir, she said, do you recognize this email? The defendant looked. Too long, just a second too long, the kind of pause jurors notice even if they don't know why. Yes, he said, it appears to be an email. She nodded, still neutral, still almost friendly. And that's your email address, correct? Yes. And you sent this on March 12th of 2023? Another pause, shorter this time, more controlled. Yes. The trap closed quietly. Let's read the first line together, she said, turning slightly so the jury could see both of them at once. You wrote, I'm increasingly uncomfortable with how these asset values are being presented. Some numbers don't align with internal estimates. She looked back at him. That's your language, correct? Yes. No denial. He couldn't afford one. She didn't pounce. That's what amateurs do. Instead, she took a step back and let the weight settle. Help the jury understand something, she said. When you wrote numbers don't align, what numbers were you referring to? The defendant cleared his throat. I don't recall the specific context. It could have been preliminary. She cut him off gently. Sir, the next paragraph references loan collateral valuations submitted to third parties. That's not preliminary, is it? A flicker, barely visible, but it was there. No, he said, those would be final submissions. The prosecutor nodded once. So in March of 2023, you were already concerned about discrepancies in valuations that had been submitted externally. She let the sentence finish itself. Yes, he said, quieter now. The defense attorney shifted in his chair. He hadn't objected. He couldn't. Everything was clean. Everything was his client's own words. And yet, the prosecutor continued, voice steady, you testified earlier that you first learned of any valuation discrepancies in November of 2023. She let the contradiction hang in the air like smoke. Help us reconcile that. This is where most witnesses try to escape. They say they were confused. They say it wasn't serious. They say someone else handled it. He tried a version of all three. I had concerns, he said, but concerns aren't knowledge. I didn't know anything improper had occurred. The prosecutor didn't argue. She smiled faintly, the way someone does when the next move is already decided. Let's look at the last sentence, she said. She read it slowly. If these figures are overstated, we could be exposing ourselves legally. I need this resolved before it becomes a problem. She turned back to him. Sir, when you wrote exposing ourselves legally, what did you mean? Silence. Not the dramatic kind, the uncomfortable kind, The defendant swallowed. I meant potential scrutiny. Legal scrutiny? Yes. From whom? Regulators, lenders. The prosecutor nodded again. And that concern about legal exposure existed in March of 2023? Yes. She took one step closer. So when you told this jury you had no reason to believe anything improper had occurred until November of 2023, that wasn't accurate, was it? The defense attorney objected. Too late. The damage was already done. The judge sustained it, but the jurors had heard enough. The prosecutor rephrased. You were aware of potential valuation improprieties months earlier. Yes. No confidence left now. No edge. The foundation cracked. Because intent doesn't require certainty. It requires awareness. It requires warning signs you chose not to ignore. And now the jury had one, written in his own words. The prosecutor thanked him and sat down. No theatrics, no victory lap. She didn't need one. The defense tried to recover on redirect, but the spell was broken. Every answer now sounded defensive. Every explanation felt retrofitted. Jurors weren't asking what happened anymore. They were asking when he decided not to act. That's the moment trials turn, not with a confession, not with a slam dunk witness, but with a single document that makes the story stop lining up. And once that happens, reasonable doubt doesn't disappear all at once. It erodes, slowly, relentlessly, until there's nothing left to stand on. The timestamp alone did the damage. March 2023, 8 full months before the defendant swore, under oath, that he had no idea anything was wrong. No gray area, no wiggle room, just a date that didn't care about his story. The subject line sealed it. Urgent valuation concerns, not vague, not casual, not something you skim past on a busy afternoon. Urgent means now. Concerns means problems. And valuations, well, that was the very heart of the case. The email wasn't forwarded through layers of staff. It wasn't buried in a chain. It wasn't CC'd to 20 people where responsibility could dissolve. It was addressed directly to him, name at the top, inbox destination, unmistakable. The prosecutor didn't editorialize. She didn't add commentary. She simply began to read, slowly, carefully, like someone laying evidence brick by brick. The email detailed specific properties, addresses, asset names, identifiers that matched exhibits the jury had already seen days earlier. This wasn't abstract concern. It was operational, concrete. Then came the numbers, reported values, professional appraisals, side by side, and the gaps between them weren't rounding errors. They were millions. One property overstated by 8 figures, another by nearly double its appraisal. The email didn't hedge or speculate. It used definitive language. Exceeds, inflated, unsupported. Then the line that changed everything. The inflated valuations, the email said, had already been used in financial statements submitted to banks. Past tense, already done. That word landed hard. This wasn't a hypothetical future risk. This wasn't an internal draft still under review. This was a warning sent after the trigger had already been pulled. The courtroom reacted before anyone spoke. You could feel it move. Not a gasp, not a murmur, something subtler and worse. Attention sharpened. Jurors leaned forward as if pulled by gravity. One juror's pen froze mid-sentence, suspended above the notepad. Another glanced up at the defendant, then back at the screen, then back at the defendant again, rechecking the contradiction with their own eyes. The defendant felt it too. You could see it on his face. The confidence that had carried him through direct examination drained away in real time. His shoulders, once squared, slumped slightly. His jaw tightened. His breathing changed, shallower, faster, no longer controlled. This was no longer familiar territory. This wasn't a debate about interpretation. This wasn't lawyers arguing over intent. This was his own inbox talking back. The prosecutor continued reading. The email didn't just flag discrepancies. It recommended action, immediate action. It urged a review, a halt on further submissions, a correction before exposure widened. Exposure. That word surfaced again. Legal exposure, regulatory exposure, financial exposure. The email didn't accuse, but it warned, and warnings are dangerous in court because they destroy plausible innocence. Warnings mean awareness. The defense table went still, no objections, none possible. The document spoke for itself, and it spoke fluently. By the time the prosecutor finished reading, the question in the room had changed. It was no longer did he know, it was what did he do after this? And the answer so far was nothing. No corrective filing, no disclosure to banks, no halt to the use of the numbers, just months of silence followed by testimony claiming ignorance. The jurors didn't need legal training to understand the problem. They live in the same world as everyone else. They know what happens when you receive an email labeled urgent and choose to ignore it. You don't get to pretend later that you never saw it. The defendant shifted in his chair, eyes fixed straight ahead now. Not on the screen, not on the prosecutor, anywhere but the evidence. Because at this point, the email wasn't just contradicting him, it was redefining him. It reframed his story from unaware executive to warned decision maker, from someone misled by others to someone alerted and unmoved. That's the difference between mistake and intent, between negligence and knowing risk. The prosecutor let the silence stretch just long enough to let the jury absorb the weight of it. No rush, no pressure. She didn't need to push. The document had already done the work. In trials like this, there's always a moment when the narrative fractures, when two versions of reality collide and only one survives. This was that moment, and everyone in the room knew it. Then came the question, "Sir, did you receive this email in March of 2023? There was a pause. "I receive hundreds of emails," the defendant said. "I don't remember everyone." The prosecutor didn't flinch. "Let me help refresh your recollection," she said. "Did you respond to this email?" She introduced another exhibit. It was his reply, sent just 17 minutes after receiving the original email. His words were projected onto the screen. "I understand. Let's discuss internally before taking any action." That single sentence shattered the defense narrative. You don't respond 17 minutes later unless you've read the email. You don't say, "I understand," unless you comprehend the issue. You don't suggest internal discussion unless you recognize a problem that requires strategy. 8 months before November 2023, the defendant knew, and that alone would have been devastating. But what happened next was unprecedented. The defendant attempted to explain. He suggested he may have been referring to something else, a different issue, a misunderstanding. That's when the judge intervened. "Counsel, approach the bench." Both attorneys moved to sidebar. The judge instructed them to use headphones so the jury could not hear, but the court reporter recorded everything. We now know exactly what the judge said. She informed counsel that she had reviewed these exhibits during the lunch break. She had read the full email chain, and in her view, the defendant's testimony that he did not remember or understand the email was not credible. She said the language of his response made it clear he understood precisely what the email concerned. She stated she was considering instructing the jury that they could consider this contradiction when evaluating the defendant's credibility. The defense objected immediately. Credibility, they argued, belongs solely to the jury. The judge agreed in principle, but clarified something critical. While juries decide credibility, judges are permitted to highlight evidence that directly contradicts testimony, and in rare circumstances, they should. Then she did something extraordinary. She turned to the jury. "Ladies and gentlemen," she said, "I want to draw your attention to exhibits 47 and 48. These are the email and response we just discussed. I instruct you to carefully review the language in these documents. Consider whether the defendant's response indicates he understood what the email was about, and consider how that might affect your evaluation of his testimony that he did not know about valuation concerns until November of 2023. That is about as close as a judge can come to saying, "This witness is not telling the truth," without using those words. Judges almost never do this. They are trained to remain neutral, to let the evidence speak, to avoid signaling opinions. But judges also have authority, and in this case, the judge used it. And when a judge tells a jury to pay special attention to evidence that contradicts a defendant's testimony, juries listen. They trust judges. They know judges have seen thousands of cases. They know judges recognize patterns. That intervention alone would have been damaging, but the prosecution wasn't finished. They introduced 14 additional emails, all from March through July of 2023. Each referenced valuation issues, appraisal discrepancies, or bank documentation. Everyone was sent directly to the defendant. Some he responded to, others he forwarded with comments. The pattern was undeniable. He asked whether banks needed to be notified. He questioned whether an outside firm should be brought in. He instructed staff to hold off on changes until we have a strategy. This wasn't ignorance. This was involvement. This was knowledge, deliberation, and delay. And critically, this was exactly what the prosecution needed to prove. The judge's intervention came early after just 2 emails, but I believe that moment emboldened the prosecution to keep going, and by the time all 14 were shown, the defendant's credibility was gone. Criminal trials often hinge on one thing: belief. If jurors believe the defendant, they acquit. If they don't, they convict. When a defendant testifies, credibility becomes the case. Here, the defendant told the jury he didn't know until November. The documents proved he knew in March. That's an 8-month lie. Once jurors see that, every other claim becomes suspect. Did he really trust his advisors completely? Did he really think everything was proper? Did he really have no idea the valuations were inflated? When jurors catch a defendant lying about one core fact, they assume he's lying about the rest. And then came the final question. Sir, the prosecutor asked us, after receiving all of these emails about valuation concerns between March and July of 2023, what action did you take to address the problems? He tried to deflect. He said he was waiting for recommendations. The prosecutor cut him off. That wasn't the question. What did you personally do? There was no answer, no corrective action, no notification to banks, no amended statements, just business as usual. That's not negligence, that's consciousness of guilt. Knowing something is wrong and choosing not to fix it because fixing it exposes the fraud. Shortly after that, the prosecution rested. The defense offered a few character witnesses, but it was over. The jury saw the lie. They saw the documents. They heard the judge highlight the contradiction. In my experience, when that happens, deliberations don't take long. The prosecution proved knowledge. They proved intent. They proved the acts. But more importantly, they proved the defendant lied to the jury. That's what jurors remember. That's why convictions happen. I will be watching this case through verdict. Based on what I observed, I expect a guilty verdict, and I believe it will trace directly back to that moment at 2:47 p.m. when a judge exposed a lie and told the jury to pay attention. Let me know what you think. When documentary evidence so clearly contradicts testimony, should judges point it out, or should juries always be left to find it themselves? I read every comment.